Could you talk a little bit about the death penalty phase and why mental health is a mitigator, or what you're looking for, what you're presenting to the courts in those situations?
So, Danny, I was involved. I was a state witness. Remember, I testified in the case in a pretrial motion for the admissibility of social media. Interestingly enough, so some of the things that he was watching, viewing on YouTube, the killer in that case, whose name I still don't want to use to try to not immortalize him or make him famous as a result of his deplorable actions.
Agreed.
But I was intricately involved and saw all aspects of that case from start to finish. Over 40,000 pages of documents to review, not to mention videos and audios, et cetera, of his kind of life history. And what I would tell you is that in terms of the death penalty sentencing, in that case, the defense, they accepted that he was guilty. So they pled guilty on the case. And what they did at that point was that averted a trial in regards to the guilt phase, right? Is he guilty or not guilty? Did he do it? Did somebody else do it? Was he mentally ill at the time? So there's an insanity defense, or was it self-defense? So they abandoned that. The defense team made the decision to do that, plead him guilty. After all, it was on video, school video. And so as a result, the only question left was life or death. The state said they're going to go forward with a death penalty sentencing on this. And so that phase in front of a jury only has to do with what happens to that person. In death penalty cases, only one of two things can happen, either life in prison or death. So that was the gist of what occurred with the jurors there and the presentations that were made over many weeks in Judge Shear's courtroom, and being able to try at that point to convince jurors that either a person's acts were so atrocious and terrible and awful and heinous that they should get the death penalty, or that there were mitigating factors in this person's life and his upbringing in terms of how he interacted with the world and how people treated him that made him stand out, and there where he shouldn't get the full brunt of the punishment that was possible in this case, which was the death penalty, and instead get life. And in this case, one and then later two of the jurors decided that they felt life was a sufficient punishment. And at that time, that was sufficient. Florida has changed their jury vote since then, but at that time, it only took one juror to say that they felt life was an appropriate sentence for a person in a similar situation to get life in prison as opposed to the death penalty.